I didn't commit the crime, but has yet to be accepted by the courts. So that's what I'm fighting for, to seek justice.
19-year-old Adonius Collier was shot dead in a wooded area of Herman Park in Houston, Texas on the night of May 14, 1992. 3 years later, on July 26, 1995, a jury convicted Nanon Williams of capital murder and sentenced him to death. The state argued that he had shot Collier first with a 25mm caliber handgun and then from close range with a shotgun to the head. Nanon Williams has consistently maintained that he did not shoot Adonius Collier.
Describe for me what your childhood was like.
My mom was in prison, a couple of times during my childhood. My father was a drug dealer. It doesn't mean he was a bad person, but he did what he thought was best, to take care of the family. He was kicking off letters. So when I grew out, with not a stable place. I grew up, I guess, always conscious of what took place around me. Always looking out for my brothers and sisters. Always worried about my mom. Always trying to be the man I wasn't.
So the state said it was a drug deal gone bad.
That's right.
And lawyer Morris Moon says there were 4 men in Herman Park that night. One of them, Nanon Williams, who prosecutors said shot and killed one of the other men. A conclusion based in part, again, on evidence involving the same HPD firearms examiner from the crime lab. Witnesses claimed Williams had a gun, a .25 caliber, and the HPD firearms examiner testified the bullet that killed the victim was also .25 caliber. But on appeal, it turned out that was wrong. The bullet was actually a different caliber entirely, a .22. Why was that so important? Because another man at the scene was carrying a .22 caliber gun. And it turns out, an expert said, and HPD's examiner admitted, the bullet actually came from that other man's gun. So what about that HPD examiner's original conclusions? The defense expert said at best they showed extreme carelessness on his part, and at worst called into question his expertise. In fact, the expert said if the bullet had been correctly identified in the first place, it might have materially affected the outcome of the trial.
Do you think that they would have convicted him without that firearms examiner's testimony?
Absolutely not.
And it turns out some of the jurors on the case agreed. One saying in this affidavit the information would have raised a reasonable doubt. And so she said, I would have acquitted him.
So what kind of situation do you have here then?
Well, what we have is we have a death sentence and conviction for capital murder coming out of Harris County based on unreliable evidence.
Police DNA lab, whether faulty findings sent possibly innocent people to prison.
But the State Court of Criminal Appeals turned it down. We called the prosecutors on these cases for their comments. Both were unavailable.
An important part of the evidence presented by Williams' prosecutor came from Robert Baldwin, a Houston Police Department ballistics authority. During the trial, Baldwin told the jury that the bullet found in Collier's head was a 25mm caliber, thereby indicating that Nanon Williams was the shooter. But subsequent firearms testing during Williams' appeal revealed that the HPD crime lab technician had erred. The bullet actually came from a .22 caliber Magnum Derringer carried by another assailant. That weapon was the only one recovered, but was not tested by Baldwin. In 1998, Baldwin wrote a report confirming his error, and 3 jurors who served on Williams' panel have submitted affidavits saying their verdicts would have been different had they been informed of the proper ballistics. On March 1, 2005, a closely divided Supreme Court ruled the death penalty unconstitutional for juvenile offenders. In the majority opinion, Justice Anthony Kennedy stated, "The age of 18 is the point where society draws the line between childhood and adulthood. It is, we conclude, the age at which the line for death penalty eligibility ought to rest." Their decision to strike down the death sentence that had been imposed on Christopher Simmons by a Missouri jury in 1993 affected 72 others on death row, including Nanon Williams. On March 29, 2005, less than a month later, United States District Judge Nancy F. Atlas granted Nanon Williams petitioned cross-claim for partial summary judgment as to his claim that imposition of the death penalty was unconstitutional because of his age at the time of the offense of conviction. But she denied his motion for discovery of evidence.
This case has been tainted by and corrupted by such false implications and false evidence, and the evidence alone should have granted Nanon a new trial. Well, in 2000, Judge Joan Campbell agreed that he had ineffective assistance of counsel, and she had recommended a new trial for Nanon. Well, the CCA, being that the pro-death penalty court that it is, ruled to affirm his conviction, and they wrote a paragraph explanation and affirmed his conviction.
Oh, I ain't so proud anymore. Peace go with your brother. Recognition don't come cheap anymore. You my lawyer, you my doctor, yeah, but somehow you forgot about me.